Can you help me get the questions ready? Good afternoon, ladies and gentlemen. This is Dr. Olu Asekun here. Thank you for joining us today. We apologize for not coming on last week. We had a trip to Nigeria with the entire team. Thank you again for joining us today. This is our weekly podcast, and it's every Wednesday, 6 p.m., 12 p.m. Central Standard Time. That is 1 p.m. Eastern. And that is currently, I think it's 7 p.m. right now
6 p.m.
in Nigeria.
6 p.m.
Is it? We are 7 hours ahead. No, this is summer. Time has changed.
Oh, it has changed now?
Yeah.
Oh, okay.
It's 7 hours right now.
But it was 6.
Or were we calculating
Well,
time wrong?
6 or 7 p.m. in Nigeria, we were probably calculating wrongly. During summer, it's 7 hours. During winter, it's 6 hours behind. Okay, so welcome again. Today, we are discussing the President Biden's executive release. While we were on vacation, there was an announcement regarding President Biden's executive power. Now, we've been receiving questions. People have been calling to ask whether they are eligible under the Biden proclamation and all of that. So because of the huge number of requests, that is why we've decided to do this podcast on this topic today. So today, if you have any question relating to the executive order by President Biden recently, you are free to start sending in your questions right now. While waiting for questions, what I'm going to say here is that the executive proclamation basically addresses only one type of immigrants, and those are the people who enter the United States illegally. What does illegally mean? Illegally simply means entry without inspection. In other words, if you enter the United States with a visa, either visiting visa, student visa, working visa, fiancé visa, immigrant visa, any kind of visa, if you enter the United States with a visa, this executive order does not affect you. It only affects those who enter the United States without a visa. We call them illegal entrant, entry without inspection. That is, those who jump through the fence, or those who maybe swam through the river, or those who hide inside a truck or bus or something. Illegally, you found yourself in the United States without going through the process, without going through the embassy to apply for visa, without being given visa at the port of entry, without being even admitted or even inspected by CBP officers at the port of entry. Those are the only categories of people affected by this executive proclamation. Now, why is this important? The reason why it is important is that for immigration law, the law as at today, the law is that if anybody enter the United States without a visa, they cannot change their status in the US. They cannot adjust their status in the US. So generally, when people come into the United States without a visa or without being inspected, the law is that such people, even if they are married to a US citizen, they must return to their home country in order to go and complete the process, in order to go and apply legally. However, for such people, if they step out of the country to go and apply for visa legally, they will be barred from re-entering the US because of that initial entry. So generally, before now, people who are in that situation, they will be required to apply for a waiver. We call it I-601A waiver, waiver of unlawful presence. So if you did not enter the US legally and you subsequently married a US citizen, for you to be able to get a green card, you will be required to apply for unlawful presence waiver. Now, even after that waiver is granted, you will still be required to return back to your home country and go through the embassy and apply for immigrant visa. And then the waiver that has been granted will now prevent you from being denied because your illegal entry will have been waived. So that was the position of the law before this executive order. So what the executive order did, it didn't change the law. The executive order did not change the law. What the president did was to use its executive authority to allow people in that situation who met the conditions to be admitted. Now, there is something called parole in place. So it's like, okay, you entered illegally, but now what we are going to do, we take you back to the port of entry and now parole you, allow you to come in legally. So if you are now paroled in place, that will now give you the opportunity to be able to apply for green card in the United States without having to leave the US or even being required to now file a waiver. That is what the executive authority does. It does not change the law. The law still remains that you cannot apply for green card if you did not enter the United States legally. So that illegality is what the executive authority is trying to cure within its limited authority. So because the law requires that you cannot adjust your status except you enter legally. So what the parole in place does is that the parole in place will now allow them to admit you legally. So that will now give you the ability to be able to apply for adjustment of status, like someone who entered legally with a visa or someone who was paroled into the United States. So that is what the executive authority is all about. And now there are some conditions. So even if you are married to the United States citizen and you did not enter the United States with a visa, if you enter IWI, the executive authority may not affect you. You may not benefit if you don't meet the conditions. There are two basic conditions that must be met. One, you must have been living in the United States for at least 10 years. That is one of the conditions. And the second condition, you must not have criminal record or be deemed to be a danger to the security of the United States. In other words, you cannot have anything to do with terrorism and you must not have criminal record. So those are the conditions. You must have been living in the US for at least 10 years. You must not have criminal record and you must not have any security issues. Of course, you have to be physically present in the United States to be able to benefit from this. So even if you had lived in the US for 10 years and then you departed, as at, I think the date was June 17, as at June 17, if you are not in the United States, you cannot benefit from this executive order. So that is what that is what this order is all about. And secondly, the order was also extended to dreamers who obtain a college degree from an American university. Such dreamers, if they have an employer willing to petition for them, willing to sponsor them, they can actually apply for H-1B. That is a non-immigrant employment authorization. Again, the executive order gave the dreamers the ability to apply for that, assuming they are not married to a U.S. citizen who are willing to petition for them. Also, it is important to also mention that talking about U.S. citizen petitioning for people in this category who entered IWI, it is important to state that it also covers parents and it covers step parents or stepchild. So if your parent is married to a U.S. citizen and you are a stepchild who also entered into the United States IWI, you can actually benefit from this executive order for as long as you meet other conditions. So that is what the President Executive Authority that was recently released, that is all what it's all about. And finally, before I go into questions, I want to state, remember, this was an executive authority. For it to be effective, it's going to take time. It is not effective yet. Do not let anyone defraud you. There is nothing to be filed yet. So even if you meet the conditions that I've explained, as at today is June 26th, as at today, nothing is available to be filed. Do not allow any notarial or even any lawyer to defraud you. There is nothing. Let me explain this. America is a country of law. Before anything can be filed, it has to go through the Federal Register. Procedures will have to be announced and approved. They will go through step by step of how this is going to work, and they will announce it in the Federal Register. They will give people the opportunity to comment in the Federal Register about the procedure, about the amount, the amount to be charged, about the form to be used. All these things have to be in place before any application can be filed. So, my friend, it is fraud. Do not allow anyone to defraud you. One thing I will assure you on this program, whenever the program, whenever the application is ready, we will notify you either during this program or in one of our daily reels. We will notify you. Right now, there is nothing to be filed. If you believe that you meet the requirement as we have explained, all you need to do is to gather your documents and be prepared. That is it. And avoid anything that can make you fall out of favor with the law. Don't get into any criminal activities. That is all I can tell you as of today. But right now, there is no application to be filed. No applications have been determined. No filing fee has been determined. When the president makes an order, there are people who are going to sit down and come up with modalities, come up with procedures, come up with the fees, come up with what form name or number. There are people who are going to come up with in preparing the form to determine what kind of questions will be in the forms. So all those things have to be in place before anyone can file any application. So right now, there is no application to be filed. Very important. Now, I believe that you already have some questions. So, please, I think I may have inadvertently closed it. So keep sending in your questions and then we will thank you.
Again?
Maybe, I don't know, but it's probably just too sensitive. Okay. I don't know what is going on. Can't we scroll up? I tried to scroll up, it was going to something else. Whenever I try to scroll up to read the question, it's going to something else. Okay, thank you. Okay, the first question: will this apply to me if I entered with someone else's legal document? That is a very technical question, because if you entered with somebody else's legal document and you are admitted at the port of entry, because when we say iwi simply means no inspection. You didn't go through any CBP officer. But if you enter with somebody else's passport, somebody else's identity, the fact remains that you are still inspected at the port of entry. You are the document just didn't belong to you. So in order to be eligible for adjustment, you will still need to apply for a waiver, because that is misrepresentation. Using somebody else's identity is misrepresentation. So you will still need misrepresentation waiver. So this particular program may not be for you, because when you enter iwi, they are going to ask you, which port of entry did you enter from? What date did you enter from? And of course, if there is a record of your entry, especially I don't know the time you entered. I know that in some cases when people enter, their biometrics are taken, and in some cases in the past, I know that people used to enter without any biometrics being taken. So if there is no biometrics, you may be able to claim that you entered without inspection. But if there is biometrics, the biometric will only show a different name, and you will not be eligible for this executive order. What I'm going to advise whoever sent this question, I'm going to advise you to be a little patient. Let the government roll out the modalities for applying. Let them roll out let us see the forms and the kind of questions that will be contained in the form. Then after that, I will suggest that you come for consultation, and we will look at it on a case-by-case basis. But generally speaking, using my experience, experience as a lawyer of over 30 years, I can tell you that you are probably going to need a waiver of misrepresentation. But again, it's too early to determine that. Let us be a little patient, and let's wait and see what the forms will be. The next question: how soon can we apply? Well, I think I already answered that. Right now, there is no application. Don't let anyone defraud you. If anybody tells you this is, oh, come and pay this, they are lying, because we don't even know how much they are going to charge. No applications has been prepared. No modalities has been set up. They are still working behind the scene on all those things. And when they are ready, they can't just even say, oh, start doing this. It's going to go through another procedure. It's going to be published in the Federal Register, and they are going to allow comment before they finally approve the final version. And it is only after that we can tell you when to apply, how much you will pay, and all of that. But one thing I can tell you is that the parole in place, according to the executive order, the parole in place will be valid for 3 years. So whenever they start, you are going to have at least 3 years to apply. So there's no way you can miss it. Anybody who is eligible, from whenever the program starts, they are going to have a period of up to 3 years to apply. The next question: do you know what the filing fee will be? Again, there is no information right now. There is no form yet. There is no fee yet. But whenever these things come out, we will either come up on this program and state it, or we state it in one of our daily reels. But as of today, there is no information about that. No amount has been fixed and no form has been determined yet. Where do I buy that shirt? Which shirt?
Your shirt, someone liked it.
Oh. Well, thank you for the shirt, for the comment. That's really, incidentally, I don't even remember. Honestly,
Was it a gift? No, you bought it.
honestly, I don't remember. I've had it for some time. It was probably either a gift or something. I honestly can't remember. I was wondering what was the question. Okay, the next question. How can I prove that I've been in the US for 10 years? That's very easy. In this day and age, there is a fingerprint of our daily activities. There is no way anyone will live in the United States and not have a paper trail. Where are you living? If you are renting an apartment, you have lease document. If you have a bank account, you will show when the account was opened. If you have a debit card, it will show daily activities. If you have a credit card, it will show daily activities. If you receive mails will come to your address. Even if your name is not on the list, your mails will still come to your address. If you get married to a US citizen, that's a public information. Your marriage record will show that you appear in person. And I can tell you, even from the date of your marriage, you will receive a lot of marketing mails. People will be sending you mails to come and apply for one thing or the other. I mean, if you are working, whether under the table or anything, I mean, if you have a car, you register it, you probably are going to have insurance, maybe renters insurance at your house, maybe auto insurance for the car you are driving. I mean, there are some things that is not possible in the US. Maybe with the exception of New York City, I don't know of any state where you can live in the United States and you will not need to drive. And in order to drive, even if you don't have papers, you still need insurance. You still need auto insurance. They don't require legal document for you to obtain auto insurance. So if you have insurance, that's another proof that you are here. And if you have a ITIN and you are filing taxes, that's going to be another proof that you are here. If you are married to a US citizen, if you have children, you take pictures. Maybe you go to the hospital or take your child to the hospital, or your wife or your husband. I mean, there is no way you will not have things that will show paper trail. In the past, yes, it may be difficult, but in this day and time, because of the public record, because of the high level of technology. What's going on? There's something flying around here. So because of the level of technology, it is almost impossible for you to live in the US and not have a record. What about cell phone? You are going to have cell phone. The number will be assigned to you. The phone record will show your calls. It will show your location where you are making the calls. There are so many things that you can use to prove that you have been physically here. It's going to be almost impossible for anyone who is physically here in the US to not be able to show it. Of course, you can also rely on a third-party affidavit. For example, if you have a roommate, they can attest to it. They can show pictures. In this day of selfies, I mean, there are so many things that it's almost impossible not to show that you are here. You are here, you are here. And that evidence will surface. So when we get to the bridge, we cross it. So, and I'm sure once the form is once the form is released, it will also come with instructions of the kind of evidence that immigration is going to accept as proof of your physical presence here in the US. Question. So, if I'm granted this, will I automatically get my green card? No, no, no. Remember my explanation. The parole in place is going to give you the opportunity to be able to apply for green card. So what that means is that even if you get the parole in place, if you don't apply for green card, you are not going to get green card. And like I said earlier, the parole in place is going to be valid for 3 years. So you will have 3 years to apply for green card. So even if you get the parole in place, if you don't apply for green card within 3 years, you may still not be able to get green card. In addition, even if you get the parole in place and you apply for green card, you still have to meet the requirement of green card. Everyone who is applying for green card in the United States must pass a background check to show the lack of criminal record. You still have to meet that requirement. Everyone applying for green card in the United States must submit medical examination to show that you are not disqualified on the ground of health, because there are some medical ailments that still disqualify people, and I think is it hepatitis A or B or things like that. So you still have to meet that requirement. Thirdly, you still have to show that you are not a risk to the United States. You still have to show that you are not connected with terrorism. You are not a danger to the security of the United States. So you still have to meet all of those conditions, and you still have to apply. If you don't apply, getting you a parole in place will not serve any purpose. What the parole in place does, the only problem is solved is that aspect of not coming in legally. So when you are given a parole in place, you are put in the same situation with somebody who came in with a visa and then overstay. So you will be in that same category. So somebody who come in with a visa, even if they marry a US citizen, they still have to apply for green card and they still have to meet the requirements. So all those things you are still going to have to do. The only problem that is solved is that illegal entry. So it's just going to give you parole in place and now give you the opportunity to apply for your green card in the United States without having to go back to your home country. That is the only thing it does. It does not give you green card automatically. The next question. Could this policy be taken away if Trump is elected president? Oh yes, oh yes. This is one of the major differences between executive authority and legislative authority. Under the law, under the Constitution of the United States, only the Congress can make laws. Only the Congress can make law. There are 3 arms of government. We have the executive, which is the president and his cabinet, all the cabinet ministers, attorney general, transportation secretary, all of those things. Those are the executive. Then we have the legislature, which is the Congress, the House of Representatives, and the Senate. And then you have the judiciary, which is the court. So those are the 3 branches of government. The role of making law is exclusively that of the Congress. So if this pronouncement has been enacted a law by the Congress, then it is final. No president can change it, whether the president like the policy or not. That is the law of the land. However, because the executive, headed by the president, they are the one that implement the law. Now, in the course of implementation of the law, they determine how the law is to be implemented. So it is that power of implementation that the president is using in this case. The Congress has stated that the Congress has already passed a law that for anyone to apply for green card in the United States, such people must either come into the US legally with a visa or must be paroled into the United States after inspection at the port of entry. Now, that is the law. What the president did is not to violate the law. They are now trying to parole these people so that they comply with that requirement of the law by paroling them, because the law is that if you did not enter the US legally or you are not paroled, you cannot apply for green card. So what the president is doing in implementing that law, they now want to comply with the law by paroling these people. That is why they set up this parole in place. So it is not a law. It is the implementation of the law. So if any new president come into power and they don't like it, yes, they can reverse it. That was exactly what happened to DACA. Remember, DACA was never passed as a law by the Congress. DACA was an executive authority of President Obama. So when President Trump came, he decided he was not going to follow it. And of course, some Republicans also challenged it in court that it was beyond the authority of the president, and the court agreed. That is why DACA got stopped. That is why DACA does not accept new applications. That is why DACA beneficiaries face all the problems they are facing today. But again, anything that is any authority that is based exclusively on executive power can be reversed by any subsequent president. So it could be taken away if Trump became president and does not like it. Yes, it could be taken away. The next question. I have a fiancée and have been here for more than 10 years. If I marry her now, will I be eligible? Yes, if you enter without inspection, yes. Even if you entered legally, if you marry your fiancé who is a US citizen, yes, you can apply for adjustment of status. If you entered legally, you don't even need to wait for this program to take effect. If you enter legally and you are married to a US citizen, you can always apply for adjustment of status. But if you did not enter legally, if you entered IWI, entry without inspection, then you have to wait for this program to commence. But in the meantime, you can get married to your fiancé. Yes, you will be eligible. The next question. Will I be able to apply for organization while this is pending? Again, I believe the answer is yes, but I'm going to ask you, let us be a little patient. I don't want to speculate. Speculation could be misleading. I'm not part of the implementation team. Let us wait for the implementation team. This policy was announced on June 17, and since that day, I can assure you there is a team that is currently working on the modalities. And once they come up with the modalities, they will publish it in the Federal Register and then wait for people to comment. And after the comment period, they will come out with a final policy. And that is when we will know what the rules and regulations are, what the requirements are, and what the details are. It is at that stage that we will know all of that. But my suspicion is that once you have parole in place and you apply under this program, yes, you'll be able to get work authorization. When they parole in place, they will give you employment authorization that is valid for 3 years. Like I said, within that 3 years, you have the opportunity to apply for green card. Within the 3 years, you'll be able to get authorization to work for 3 years. The next question. My wife was a permanent resident but became a citizen on Monday. Is there a way that this policy could apply to me? Well, whoever is asking this question didn't indicate whether he entered IWI or not. Assuming that you entered IWI, yes, and you have been here for 10 years, yes, and you do not have criminal record, yes, and you are not a threat to national security, yes, if you meet all the conditions, yes, it should apply to you to apply for parole in place. However, if you entered legally, maybe you came in with a visiting visa, you don't need to wait for this program. Once your wife became a US citizen, she should be able to petition for you without you having to wait for this program. So that is the difference. The next question. If I'm granted PIP, can I travel outside of the US? I don't think so. This PIP, parole in place, is specifically for you to be able to apply for adjustment of status. It is not in itself a visa or something that grants you authority to go in and out of the US. So, no, you cannot use the parole in place to travel. It is meant for you to apply for green card. It is meant only to apply for green card in the United States without having to depart for your home country if you entered IWI. It will also give you employment authorization, but it does not give you the ability to travel in and out of the country. The next question. Will there be lawsuit filed to prevent implementation of this program? If so, what would that mean? Again, these are speculative questions. There is no way that I can determine whether a lawsuit excuse me, will be filed or not. But if the information we are getting from the news is to be believed, and I think somebody has already even filed a lawsuit to challenge this executive order. If the information in the news is to be believed, someone has already filed a lawsuit to challenge this executive order that the president does not have the authority. But again, I don't know how the court is going to rule. Remember, several times people challenge DACA, even though DACA is not accepting new applications, but the fact still remains that everyone who were previously granted DACA, they are still using it. So we can't really predict how the lawsuit will play out. But right now, the program has been announced, and once they announce the implementation, I'm sure USCIS will start accepting applications, except there is a court order stopping it before implementation. The next question. If I'm currently in removal proceedings and I believe I'm eligible for PIP, can this be a relief for me? Oh yes, oh yes. Once there is a relief, it doesn't matter whether it is affirmative or defensive. If the program is announced, if the application is set up, the fee is set, and the filing date is announced, if you are eligible, even if you are in removal proceedings, yes, you can apply for it as a form of relief. So for now, start gathering all the evidence that you have been here for 10 years. If you have any criminal issue, make sure you apply for the police incident report, get the charges and get the disposition, get all these things ready. Gather evidence that you have been here in the last 10 years. If you have been filing your taxes, start gathering your tax return. If not, look at all your addresses in the last 10 years. Anything that can prove that you have been here, start putting them together. It doesn't matter whether you are in removal proceedings or not, you will still be eligible. The next question. USCIS website says that individuals must not have disqualifying criminal history. Do we know what they mean by disqualifying criminal history? Yes, as I stated before, this executive order does not change the law. There is an existing law. Anyone who is applying for green card in the United States must meet certain requirements. Number one, you must show legal entry into the United States. For those who entered without inspection, that is what this executive order is attempting to cure. Now, assuming that problem is cured, you still have to meet the other conditions. Excuse me. Anyone applying for green card in the United States must meet health condition. You must go for medical test, medical examination, and the medical examination must show that you do not have disqualifying health challenges. Anyone applying for green card must go through background check. So they must go through your background check and be sure that you do not have disqualifying criminal activities. Now, there are different types of crimes. There is something called misdemeanor. Misdemeanor simply means simple offenses, offenses that are not felonies. Maybe minor offenses, offenses that the punishment is just maybe citation, maybe fine. Maybe for example, speeding. For example, there are a lot of minor offenses. Even misdemeanor, there are categories. There is a misdemeanor B, which is the lowest category, and there are some misdemeanor A, which can still disqualify someone from getting green card, especially where there are more than one A misdemeanor. If there are more than one, it may be a problem. Then we have felonies. Again, even felonies have grade. We have first degree felony, we have second degree felony, we have third degree felony. And then we have the father of them all, aggravated felony. Now, I can tell you up front, aggravated felony is a major problem, because even if you already have green card, they will take it away from you if you are convicted of aggravated felony. That is a major one. Now, if you have other felonies, depending on the nature of the offense, every offense is not the same. You may have two felonies and one is able to get green card and the other is not, because there are different classes of offenses. For whoever asked this question, I'm going to refer you to our podcast on I think we did something on crime and immigration consequences. So there we explain the way immigration classify criminal offenses. There may be some offenses under state law that constitute felony, but for immigration purpose, it may constitute aggravated felony. For immigration purpose, let me tell you this: aggravated felony are offenses for which the punishment is at least 12 months, either in prison or probation. It is aggravated felony. So even if it is a traffic offense and maybe you allow the traffic offense to escalate, for example, maybe a policeman stop you for speeding and you refuse to stop, maybe it led to a pursuit, and then maybe in the process you had a crash with, so all those things may become aggravated felony for immigration purpose. So it is very, very important to understand it. And again, for some of these offenses, you may be able to apply for a waiver. There is a waiver of criminal conviction, but there are some offenses that cannot be waived. For example, any offense under Adam Walsh Act, that is, offenses that have to do with minor, sexual offenses against minor, maybe child molestation, maybe child trafficking, child pornography, all those things cannot be waived. If you have any of those things, forget about it. It doesn't matter whether you enter Iwi or not, you will still not get green card. And of course, it will lead to deportation. So it is very important to understand to avoid criminal activities. The next question. I have been working in the US, but I haven't filed taxes in the past 5 years. Can I still file my taxes? Well, I believe you can, but at the same time, in addition to the taxes, you can still find other evidence to show that you have been here legally. Again, I keep saying it, and I'm going to keep repeating it throughout this podcast. As at today, the modalities for this executive order is yet to be announced. So I cannot tell you today whether filing taxes will be a condition, but I don't think so, because the government probably knows that a lot of people without social security number or without ITIN, they find it difficult to file taxes. So I don't think they will make taxes a condition. But if you file your taxes, that will be an added advantage in terms of proving your physical presence. But the fact that you have not filed in the last 5 years, yes, you can still file it. The only problem is that if you owe IRS, you should be prepared to pay penalties and interest for those late filings. Other than that, you can still file your taxes. The next question. If my PIP request under this policy and I'm encountered by CBP or ICE, will I be placed in removal proceedings? I don't think this question is complete. Is it if my PIP request is granted or denied? I don't know.
It's pending.
Or if it is pending.
Filed and it's pending.
Oh, okay. So if my PIP request under this policy is pending and I'm encountered by CBP or ICE, will I be placed in removal proceedings? No. Once you have PIP request pending, it only shows, like I said, it cures the problem of illegal entry. It does not by itself give you legal stay, except where you have been granted employment authorization. Excuse me. If your PIP request is filed and then you apply for employment authorization, I believe that ICE or CBP will not place you in removal proceeding, except where you are placed in removal proceeding as a result of criminal activities. Remember, criminal activities has nothing to do with your legal status. Criminal activities has nothing to do with how you enter the US. For as long as you are not a US citizen, if you commit a crime, you can still be placed in removal proceedings. Even if you are a permanent resident, you can still be placed in the removal proceedings if you commit a crime. So criminal activities and this program, they are two separate things. So just make sure you avoid crime. But if you have applied for the parole in place and you have evidence of it, I don't believe ICE or CBP will place you in removal proceedings except if you commit criminal activities. The next question: if I apply for this PIP and the request is denied, will I automatically be placed in removal proceedings? Well, right now, based on the current President Biden's policy, President Biden's policy is that people who do not have criminal record, they are not the priority of this administration for the purpose of removal proceedings. So, if President Biden remain the president, the answer would be no, you will not be placed in removal proceedings. However, if by November a new president comes in who do not believe in this program, you may be landing in removal proceedings. So again, this is speculative, but right now, based on the current government policy and procedures, only people with criminal activities are the priority of removal proceedings. So if you do not have criminal activity, the fact that this application is denied will not lead to removal proceedings. But things may change after November. So let's cross our fingers and wait and see how the election will go. The next question: I thought that PIP was only for parents of US children who are in the military. Oh yes, that is what the current PIP is all about. But the president is now, by executive action, extending it to this set of people who entered without inspection, who are married to US citizens, who have been living in the United States for at least 10 years, who are physically present in the US on June 17, 2024, and who do not constitute a danger to the security of the United States. Yes, the president is extending it beyond the parent of US citizens who are in the military. So the president is using his executive authority to do that extension. So the program is still available for parents of US citizens who are in the military. It is still available, but this is an extension by executive authority. Okay, so I'm still expecting more questions. Okay. So keep the questions coming. Keep the questions coming. We have just about 10 more minutes, but keep the questions coming. Okay, I have another question. Is this only for people who came in through the Mexican border? No, no. It doesn't matter the border you came in from. Whether you came in through the Canadian border, whether you came in through the Mexican border, whether you came in, is there any other country that borders the United States apart from Mexico and Canada? Okay, so yeah, those are the only two countries that borders the United States. Either you came in through Mexico or you came in through Canada. However, even if you come in through the boat or maybe through Hawaii, maybe you came in Stowaway, maybe you came in through Hawaii and through any of the US islands. I mean, I think I've seen someone who came in, through Kano. I mean, no matter how you came in, it is not limited to Mexican border. For as long as you found yourself, you smuggle yourself into the US without going through the proper channel, without going through the CBP officers, without going through the port of entry, without going through the airport to be inspected. So, however you found yourself in the United States, for as long as you did not have any legal document that brought you in, you are considered Iwi. So, legal document does not necessarily mean passport. So even if you have a passport from your country, for as long as you didn't apply for visa, you are still Iwi. You are still entry without inspection because you didn't provide any visa that authorized you to enter the US. So for as long as you fall into that category, you are eligible for this program and you meet other conditions, which include you must have lived in the US for 10 years, you must not have criminal record, you must be physically present here on June 17, 2024, you must not be a threat to the United States security, and you must be married to a US citizen or be the step child of a US citizen. So those are the conditions. So okay, next question. Is there a limited number of people who can apply or be approved? No. So far, the program did not announce a number. However, there have been lots and lots of speculation. Some people are calculating that based on this announcement, it may be up to 500,000 people. Some are saying 50,000. All those are speculation. The program itself did not mention any number. But again, because it has not been announced on the Federal Register, when those details are announced, it is possible that they may have a numerical number or numerical limit. But right now, no such number to the best of my knowledge. It is just the analysts who are guessing the number of people who are currently living in the United States without being inspected. Based on that number, that is when they are throwing out all these numbers. But again, as a lawyer, especially as somebody who knows and who is conscious that whatever I say here can affect people, I'm not going to speculate on something that is not that may not be true. So the program, when the president announced it, he did not put a number to it. However, speculators are calculating that, okay, based on the number of people they know who are married to a US citizen and who did not enter without with a visa, that it may be up to this number. But I'm going to suggest that we wait until the Federal Register is announced to see if they will put a figure to it. But based on past experience, there has been no figure. For example, when DACA was announced, they didn't put a figure to it. And until the court stopped it, people continued to apply. People continue to apply until the court stopped it. So I'm going to speculate that there will be no numerical limit. But right now, it remains speculation. Okay, another question. If I'm in removal proceedings, does that mean that if I'm granted PIP, will the proceedings be terminated? Not necessarily. Sometimes the proceedings may be terminated if the DHS want it that way. But generally, what the PIP does is that it gives you the ability to apply for adjustment of status. Remember, adjustment of status can be, you can apply for adjustment of status with the court, with the immigration court, and you can also apply for adjustment of status with USCIS. So, if you have the PIP, it only gives you the benefit, the opportunity to apply for adjustment of status. But adjustment of status can be processed either by USCIS or by CBP, but if by immigration court. But if you are in removal proceedings, USCIS will not have jurisdiction to process your adjustment application. So the court will still process your adjustment application, but where the DHS agree to terminate the proceedings, then USCIS will process it. But either way, you still have to apply for green card, either with USCIS or with the immigration court. The next question. I came in legally many years ago. I cannot find my I-94 and CBP can't either. Could I possibly apply for this? Well, if you came in legally, what about your passport? What about your copy of your visa? Because I-94 is not the only proof of legal entry. So if you have the visa, if you have the passport, you can still use all of that to prove your legal entry. However, if you do not have any of that, then you can just apply for this program. If you are married to a US citizen and you meet all the other conditions, yes, you can just apply for the program. No harm done, especially if you have requested a copy of your entry record from CBP and they told you they cannot find it, then you can definitely apply for this program. The next question. If there is a numerical limit, does that mean that if the number of applications received is more than the limit, how will they handle the application received?
Let's continue from the right side.
Okay, once the limit is reached. Again, we are still in the speculation realm. We have to wait until the announcement is made in the Federal Register. But again, based on my experience, there is not going to be any numerical limit. Remember, this program is only meant for people who are the immediate family of a US citizen, spouses of US citizens. Generally, when you are the spouse of a US citizen, you don't fall into category of a visa limit. So you don't fall into that category. So I can tell you authoritatively that there is not going to be numerical limit because you are an immediate family member of a US citizen. One of the major requirements for you to qualify, you must be married to a US citizen. And the moment you are married to a US citizen, you cannot fall under visa bulletin. You are exempt from that category. So I can tell you there is not going to be a numerical limit. Well, that seems to be the last question for today. And I also realize that our time is over. Thank you again for watching us. Thank you for this program. Today is another beautiful Wednesday. We hope to continue our series next week. And by the grace of God, remember to join us next week. Remember to invite your family, friends, colleagues at work. And again, we have said this over and over and over. The only thing you can do to show appreciation for what we are doing, for all this free information, is to let others know about it so that more and more people will avoid errors, avoidable errors. Thank you so much. God bless you. We hope to see you again next week.